Hey there, welcome to Generations Wealth Talk, and I am Todd Watley, here with my co-host, Ian Weinder. Hey, man.
Todd, here we go.
Here we go, another fun show. And as I was driving up here, I was thinking today about a lot of things come up in the office, situations we deal with, and the title of today's show is 99% is not good enough.
Ooh.
Okay? So
that's tough.
I know. You think about a test, if you make 99, it's like, yes, I aced that test. Well, almost. You almost aced it. And so many things we see in financial stuff, legal stuff, you can get the whole thing pretty much right, but that 1% can cause some substantial issues.
It can be overweight, if you will, in the test. I was thinking about, I probably wouldn't have graduated high school if this was the same benchmark. But think of a test like that, right? Mm-hmm. Maybe it's 99 questions or multiple choice, and one is an essay, but the essay holds all the weight.
Yeah. Well,
that's kind of the idea that we're talking about today.
Yep. If your doctor does 100 procedures in a day and you go see them on that day and they got 99 things right, but the one procedure was your procedure and they just didn't get that one right, well, shoot, I got 99 right, but this one procedure, sorry, I botched that on you.
Perspective is important.
It's huge. And so what we see is, I see documents, people bring in documents, it's like, yay, I did my estate plan. Great, let me look at it. And so I look at it and I'm like, this is good. And then I'm like, this one sentence in this 48-page document, this one sentence messes everything
Lawyers
up.
aren't that picky, though. This seems a little bit dramatic, Todd.
It's not. I promise you, it is so realistic that you can have a whole lot of things right, but one sentence in this 48, 50, 70-page document can truly mess up so many things, okay? So let's talk about...
The details matter.
The details are huge. And so there's four things actually. And so let's go through those, okay? Yeah. Number one, so if you have a trust, okay, you're like, oh, I've got a trust, I'm good. Well, I encourage you to go get it out, look into it, and it's probably anywhere from 20 to 70 pages long. Look at the part that says when you die or you and your spouse are both gone, when things are going to the kids, typically, look at that section and how does it go to the kids? And if it says to my children, period, or to my children outright, what that means is at your death, your estate's going to be divided and it's going to go to your kids, okay?
The trustee is going to write a check
to the kid. Mm-hmm. And congratulations, here's your stuff, here's your inheritance. Great. Well, they now have your money. But what if they're going through what I call the big three? Mm-hmm. Bankruptcy, divorce, and lawsuits. If at the time of your death, your child is going through any of those three things, or they're being unduly influenced, or they have a drug problem, or anything's going on, at your death, if your trust simply says, to my children, period, or to my children outright, then it's going to them in a check, it's theirs, and poof, it's gone due to those legal issues. My trust, when I do this, and I used to make this an option for my clients, and then finally I was just like, this is stupid. There is no reason not to do this. And so in my trust, when we leave money to your kids, we leave it in trust. And so basically it's like, I am leaving this to my kids.
So two words.
Two words can make a huge difference. In trust, your trust creates a trust for the kids so that they get it in trust. Your kid is the beneficiary, of course, but then they are typically also the trustee of that trust, meaning that it's not owned by them, it's owned by a trust, but they benefit from the trust and they're in control of the trust, which means we give them almost full right to do anything with that trust that they want to. When I say almost, there's slight restrictions so that if a court, a bankruptcy court, divorce court, lawsuits, whatever, they come after them and said, your parents left you $1 million, you need to write a check from that to these creditors. Your kid, who's the trustee of this trust, can say, nope, the trust doesn't let me write that check.
Because the trustee has a fiduciary duty to the beneficiary. It's like wearing two different hats. They're wearing the trustee hat, and they say, unfortunately, I have a duty to the beneficiary, and I can't write that check. It's not in their best interest. They put on the beneficiary hat, and they say, thank you. I appreciate that.
It seems kind of picky, seems kind of like
but it's
splitting
just
hairs.
A little bit of language.
It's just a little bit of language that makes a huge difference. And so I see that in so many trusts, and I've had people who did a trust 6 months ago, and
we see this a lot, unfortunately. Yeah.
They come to see me, I'm like, your trust is good in almost all aspects, but it does this. And so many times people are like, that is so important to me that I'm concerned about my in-laws. I'm concerned, what's going to happen. And so they pay me to redo their trust so that language is there, knowing that their inheritance will go to the kids and will be protected.
Well, there's so much here in this that I want to slow down just a moment.
Okay.
So what someone should not do is take out their trust, scratch out the next sentence and just write in trust, right? That's probably not
that
good.
Has no effect whatsoever.
Okay, just want to be clear. Okay, so we're not giving any specific tax, legal, or investment advice on this show. This is for educational purposes only. But I love this example, and to me, this is one of the most important things that gets overlooked a lot. And I'm gonna say something that you really should, you should say, but you don't. There's a couple particular attorneys in Bella Vista that are really big that we see their trusts all the time. I'll say I see their trusts all the time. And they're all the exact same trust. Everything's been copied and pasted. Usually the trustee is the same bank. And this is frustrating to me. But this particular attorney does not distribute stuff in trust. Can you think of a good reason why you would not distribute it in trust? Is it more expensive to write those 2 words?
No. I don't know. I don't know why it's not done in every trust, every continuing legal education course should. When I teach other attorneys, I might put this language in there. There is no reason not to. It's not more expensive. And typically it's not a concern. But in that situation where the money goes to the kids and they're being sued, they will be very thankful that you did this for them.
It seems like this is one of those situations where there are folks who are generalists who they do a lot of different stuff with mixing a little estate planning on the side, and you can get about 80% of it right with that.
Yeah.
Like you could probably do a divorce if you wanted to.
I'd be about 60% right.
Yeah,
maybe.
like you'd probably get it done.
Yeah, I could get it done. It wouldn't be pretty, but I could get it done. You might lose everything, but hey.
I'm saying this a little bit jokingly, because this is really serious. The first rule of being an attorney is to only practice in an area where you're competent, and that's not always what I see when I'm working with attorneys. Okay, and so I review a lot of trusts. People don't realize how many trusts I review before they go to you, because I need to understand how this works.
Sure.
And I see this all the time. Yeah. And so this, to me, I want to be gentle. I don't want to be mean. But on the other hand, I do feel a level of responsibility that if I don't tell you about it, then it's on me. If I tell you about it and you choose to do nothing, that's fine. That's on you. Transparently. But this is an area, to me, being gentle, that it's really a matter of generalists trying to do what only specialists should be doing. Those couple words can make all the difference in really protecting everything that someone has built. Their entire estate could be protected or not protected. And another piece that I want to bring up, Todd, is you might be listening to this thinking, well, I've got great kids. I raised great kids. Their in-laws are great. We're not really so much worried about the kids or the heirs. I mean, in some cases we are, but not always. But who we are concerned about is everyone else. We live in a very litigious society, and when money changes hands, relationships just tend to get strained and tend to get maybe that's not your family, maybe it's just the other families that we've served.
Absolutely.
And so I say, if you're going to go to the expense of creating a trust, you've got to do it right.
Yeah.
It's worth every penny to get it done right.
Yeah, and so one other thing that I see that you may think this is really not a big deal, but it is a big deal if you go through it, and it's how do we get you as the trustee, when you create a revocable living trust, typically you're the trustee, you're the beneficiary. You benefit from the trust, but you're also in control of it. As an elder law attorney, I deal with a whole lot of people who have dementia. You know, they come to see me early stages, mid stages. They can still sign documents, they can still do things. But as that dementia gets worse, sometimes that person no longer needs to function as the trustee. They are being scammed. They are paying bills 2 or 3 times because they forgot that they paid it. They're donating money to people that they would never donate to. You know, it's just things are going on. And so in a trust, you name a successor trustee. It's typically a child or someone who's there and sees what's going on. And so they see there is a problem and they're like, I need to get you out of this row because you're incapacitated, you're not making good decisions. I need to step in and take control, I as the kid. And so if you'll go look at your trust, look at how that transition occurs. Typically there are 3 ways to do that. Number 1, you resign. Well, most people in that stage of dementia are very belligerent, very non-cooperative, and they're like, I'm fine, there's nothing wrong with me, I'm not resigning. Okay, so we go to option number 2 is you get a physician to deem them to be incapacitated, and you're like, oh, well, that makes total sense, I'll just get mom to the doctor.
Doctors know stuff.
Yeah, doctors, and they can do that. But what if mom is belligerent and she's not cooperating and she thinks you're stealing off her money when she sees $10,000 gone from her account, instantly they're like, they stole my money. No, they didn't steal your money. You just wrote checks that you don't remember. And they think you're trying to throw them into the nursing home. And so they've turned on the person that they named as trustee. And so now this person is like, hey, we want to take you to the doctor so we can deem you incapacitated so we can really take over. If mom refuses to go to the doctor, which she will, you can't do that option. Third option is court. We file an action to a court to say, hey, mom's incapacitated, she can't do this anymore, and we need you to take away her rights and give it to me so I can do this. Well, that's a horrible option.
It's public, and it's not fun.
It's just not fun. And so I throw in my trust, I throw in a 4th option, okay? That 4th option is you agree that if the successor trustee, the person that you've named that you trusted on this day, to do that, if they see the problem and they come to me as your attorney and say, hey, Todd, mom's, she's not doing well. She's losing money, paying money out, anything that's going on, what do we do? And I'm like, you just did it. You called me. And so I call my client, the current trustee of the trust, and say, hey, your daughter thinks there's a problem. Oh, there's nothing wrong with me. She's just trying to steal my money. I know. But remember in your trust, that option that if she makes this allegation that you're no longer able to serve as trustee, you have to go to the doctor and prove that you're not incapacitated. And she says, well, I'm not going to the doctor. Okay, fine. If you don't go, 30 days from now, you're out, she's in as trustee, and that's what happens typically. Either they go, and most children will not make this allegation until it is definitely time. It's probably past time. But there is no question this person is incapacitated, should not be doing this, and a doctor will probably agree with us that she is incapacitated. But what happens is the person refuses to go. And so
forgets.
5 minutes after that phone call, they're on to but if they do not go to the doctor within 30 days, they're out, the daughter's in, she can take control and do stuff. And I rarely see anyone else's trust with that option in there. And so without that option, chances are you're going to court. You're going to have to go to court and prove this person's incapacitated. That's It's public, it's expensive, it's time consuming, it's just not a good option. My fourth option fixes that problem, and everyone I've presented this to said, Todd, that makes total sense.
Well, it's a great example of another area where a generalist, it makes sense to have to go see the doctor or two doctors to confirm that.
Sometimes it's two doctors.
You know, and when you're the person who is setting up the trust, you're like, yeah, I want to be in control, and I don't want that to get taken away from me. But what you're not thinking about, and what the generalist attorney's not thinking about, is the situation where you actually need that to happen. You know, sometimes the kindest thing is to have hard conversations and make hard decisions.
Yeah.
I mean, it's the kindest thing, and it's in their best interest. And they have to decide that from the outset, and it sounds like they do.
Yeah.
But a regular attorney or just a regular person wouldn't think of that.
Yeah.
It's that little detail that makes all the difference.
So number 3, okay, the third issue that I see is with your power of attorney. You're like, oh, good, Todd, I've downloaded my POA off the internet, I'm good, or I went to my business attorney or my divorce attorney and they gave me a power of attorney. Great, okay, except one sentence can cause you to lose everything that you have. Now, Todd, don't be dramatic. Come on, really? Yes, all the time. It's like, families come in, mom's going into the nursing home, she's single, she has $300,000. Are we going to lose everything? I'm like, well, we don't have to. There are some ways we can protect at least half, sometimes 60 or 70% of that. Do you have power of attorney? Yes, we do. Great, let me look at it. And so they slide it to me. I go to one section, gifting. I look at gifting and it says, the agent shall not make gifts. And I'm like, can mom sign? No, she's completely incapacitated. She cannot sign a new document. Shoop, I can't help you.
I've watched it happen. It's exactly.
It's my worst meeting.
He does that first. Sorry.
I do, because I'm like, I don't want to say this.
He does not want to have this conversation.
Yeah. But
it's true.
I give it to him and say, this, you're the agent, we can't change that, and it says you cannot make gifts. The way we protect your assets for Medicaid, you've got to be under $2,000. The way we get you under $2,000 is we give it to the kids who you want it to go to. But Todd, there's a 5-year look back. I understand that, but we can work through that. The rules are in our favor. You know, I said I can protect half, so basically we give away half. The other half pays the penalty for giving away that half. And a lot of times with income and different things, we can actually make half be 60% that you keep, 70%. Did one the other day that was 82%. Her income was really high. We were able to protect 82% of the assets because there was a power of attorney that allowed the agent to do gifting. And if I don't have the power to do gifting in the power of attorney, I cannot help you. You will spend $10,000 a month for your nursing home care until it's gone.
So a couple points here.
Okay.
One, when we're thinking about, you know, back to generalist versus specialist, you know, if I'm signing a power of attorney, especially as a younger person, you know, I'm not necessarily thinking about this, going, do I want my agent to be able to give away all my stuff at any time to anybody?
You're not going to.
Boy, I mean, an average attorney is going to go, no, I don't want to do that because they're worried about fraud. That's not what we're worried about. And the truth is, the agent under a power of attorney is required to act in a fiduciary capacity. They're required to act as if they were the person in their best interest. And so that's really not an issue, but an average, you know, the divorce attorney or the family law attorney is not going to really understand that. Yeah. You know, having helped hundreds, if not thousands of people get through this, you understand what it takes at that point. That's huge. The other side, you know, I'm the math guy around here. You know, 50, 60, 70% is a lot higher than zero. You know,
that's good math there.
You know, and yeah, that's why they keep me around. But you know,
yeah.
And so, you know, we joke about this a little bit because this is hard stuff to talk about. But if we don't talk about it, people are going to lose everything.
Yeah.
And we run into this situation. And when we did the radio show, and we do it on this show too, the kind of tagline that we came up with is, you know, do it yourself, save a buck, and be at risk of losing a fortune. You know, you might save 99% on the front end, and on the back end,
lose everything.
You might get to keep 1%.
Yeah. It's sad. So, okay, so let's talk about financial situations.
Oh boy.
You see people bring in their financial stuff, and I would doubt that they're 99% correct. But sometimes
I've never been that close. Yeah, okay. This is one where really, admittedly, transparently, I can be really picky on stuff.
Okay.
If I want to.
Sure.
But I cannot think of a single case. I cannot think of a single situation where I've reviewed someone's financial plans, someone's statement, where it was even probably 85%. There wasn't a dramatic improvement that we could make.
And this is at the point that we see people, which is typically you're older, you're going into retirement. And so one thing that we talk about every time we do this show and every time we speak is, just like you go to a specialist doctor for a specialist problem, you should go to a specialist attorney for a specialist problem. You should also go to a specialist financial advisor for a specific problem.
Yes.
People think, oh, I've got my person I've been with them for 20 years.
And they've done great.
Mm-hmm. Okay, but now you're going from accumulating money to retirement, and that's totally different. And someone who's really good at accumulating, I'll say, is probably not that good at transitioning from accumulating to spending and doing it well.
Well, there's a couple of different issues. One is, let's say you've been working with someone for 30, 40 years, and they've done accumulation well. Mm-hmm. The first question is, what's the benchmark? We see a lot of people over the last 10, 15 years, the U.S. markets are performing above their historical averages.
Yeah.
So is it that the market's been doing really well, or is it that your investments, it's a chicken and egg problem.
Sure.
So that's number one. Number two, so what's the benchmark? Mm-hmm. What could we have improved on? Now, we don't want to spend so much time talking about what we could have done differently, but if we're starting now, what do we want to adjust? Mm-hmm. That's number one. But number two, let's say you have been working with them for 25, 30 years. Mm-hmm. Well, when they did their securities license class, which is like a weekend, the rules and the way that things work is different now. Mm-hmm.
Way different.
Retirement is completely different now than it was 25, 30 years, even 10 years ago.
2019, a lot of things changed. Mm-hmm.
Mm-hmm. And a lot of folks may not know, the largest legislation on a federal level relating to retirement in about 40 years started in 2019. Yep. And there was a follow-up in 2022. Mm-hmm. There hasn't been that much specific legislation around the issue of retirement and retirement plans in 30 years.
Sure.
That's dramatic. And what we find is, to your point about, folks who are focused on the accumulation phase, what they're good at is getting you to invest and continuing to invest, and that's important. Mm-hmm. And that's what their training and their licensure and their sales training is about. Mm-hmm. But when we get to retirement, it's a completely different thing.
Sure.
Managing Social Security, the taxation of Social Security, figuring out how to title things in your estate plan, figuring out how to pay for long-term care, if that's an issue. How do we go from building up a big nest egg into turning that into income for the rest of your life? It's a different conversation.
It's a specialty.
It's 203 and 303. And transparently, there are not a lot of advisors who focus on that. Mm-hmm. And even the ones that do, I have some criticisms of. That's a different story. But what we want to think about is this is a change of life situation. Mm-hmm. And sometimes that warrants a change of specialist. If you go to the doctor and they're like, your general physician, and they go, hey, we're noticing some stuff in the, we did a routine, scan. We're noticing something in the blood work. We want to get that checked out. Mm-hmm. You might have a cousin or a brother-in-law who's a really good, podiatrist. This is not the time to be on the family plan.
If your liver function's not looking right, you need to go to a specialist.
We go to a specialist. Mm-hmm. And so a change of life dictates, or a change of the data dictates bringing in a specialist. So really the three areas that we see the biggest issue in. Number one is fees and expenses. Yeah. And there are significant layers of fees and expenses that you may not realize. Another issue in the probably hundreds, if not thousands, of plans and portfolios that I've reviewed, no one has accurately known exactly what they're paying in fees and expenses. They might have known their advisor's fees, but they didn't know the internal expenses or some of the supplemental fees and expenses.
There are some cool software programs out there that can go in and extract that. They go through different programs and they can extract that. And when I've been in those meetings, their jaw drops. They're like, I'm paying how much in fee? $30,000 to $40,000 a year in fees.
And the reason you don't see it is because it's on the fund level.
Yeah.
And so that, what you just see is the net return. You don't see the internal expenses. So we take a step deeper, and we're, the investments that we use are less expensive on average than most of these, because we can do that more effectively. So fees and expenses is a huge one. Performance and what we actually own is another one. Most folks don't realize what they actually own. They realize they own some mutual funds or they own some stuff, but we go, okay, why do you own what you own? And if the answer is because that's what the guy, said and we've done really good, that's not going to get you through market fluctuations. What if something happens to the guy? What if, you're on the third, XYZ investment fund guy because the other two retired or one, that's not a long-term winning strategy. So we got to know what we own. And then the other really big issue is there's no plan for taxes or Social Security.
Taxes. Taxes aren't bad.
Taxes aren't that. Typically what we hear, Todd, this is really incredible to me. But I'll ask folks, I'll say, hey, what's your plan for claiming Social Security, or what's the advisor's plan? What's the current plan? And then even more, I'll say, hey, what's the plan for dealing with taxes in retirement? What does that plan look like? And they say, well, our person, they don't really do taxes, or they'll say, what they tell us is, you've got enough money, you're going to be able to cover your expenses, don't worry about it. Don't worry about taxes.
Don't worry about taxes. And I've seen you do your thing on that, and by the time they die, that's a difference of millions of dollars.
Yeah.
Okay, it's just millions,
What's a couple million between friends, right?
What's a couple million?
Our friends in Washington love that type of approach.
It's so phenomenal. I mean, it just blows my mind.
And so the goal is we want to have clarity, and we want to know, what do we own, how much does it cost to own it, and do we have a strategy to get through the most complex, the most legislatively challenging period of our life, which is retirement. And if we don't, that's an area where we want to provide a second opinion. So I think there's a lot more that we could say, but why don't we wrap it up here, Todd? And how can the folks get in touch with us?
Yeah. So give us a call. You can just call my office, 479-601-4119. That's Generations Legal Group. Ian's office is there, and I think what you'll see is we work very closely together. And if you'll allow both of us to be in the meeting together, we can solve a whole lot of problems in 1 hour. Okay, so give us a call, 479-601-4119, and we will see you next time. Thanks.